learned in class, their consideration in contract law is the foundational concept that emphasizing the necessity for a fair exchange between the parties that entering into an agreement. Essentially, it means that every party must give something of value in return for what they have received from the other party, establishing a mutual commitment. This exchange often described as conferring a benefit to the person who makes the promise, which is the promisor, or causing a detriment to the person to whom the promise is made, which is the promisee, or sometimes both. It is something of economic value or highly sought after service. This mutual aspect ensures that the promises are genuine and supported by a real commitment. However, a promise that lacking a consideration is generally viewed as gratuitous and consequently it is not typically enforceable by law. To illustrate, consider a scenario where someone promised to give a valuable item to a friend without expecting anything in return. In such a case, the promise is more of a generous gesture than a binding contract. This absence of mutual exchange makes it challenging to enforce such promises legally, highlighting the fundamental role of consideration plays in the enforceability of contract. The consideration must not be past rules, since that things you did, gifts you gave, or promises that you made in the past will not count as a valid consideration. For example, if you help someone without agreeing on payment, you cannot later claim it as a consideration for a new promise. Also, if someone finishes their part of the deal before the other mentions consideration, it is unlikely that the earlier action was done expecting something in return. Picture when doing a favor for someone and only afterward they offer something. In this scenario, it is crucial to highlight that initially the assistance is given without expecting any reward. Thereby, it cannot be considered as a consideration later. This rule promoting fairness and preventing one-sided commitment based on the past actions and promises. So, for a contract to be legally sound, the consideration must be current and concurrent.
Assalamualaikum. Hello there, Amali.
Oh, hello, Adrian.
I heard you were looking for a pen.
Yes, I need the pen now. I want to complete my assignment. I cannot find.
Don't worry. I have a pen right here. I'm not using it anyways, so take it.
Do you want to give it from me?
Yeah, I'll give it to you.
Yeah, thank you, Adrian.
Yeah, no problem.
You help me.
Okay. Assalamualaikum.
A few moments later.
Assalamualaikum. Amali.
Oh, Adrian, what?
So I would like to ask for 3 ringgit for the pen yesterday.
Huh? Why?
I mean, I give you a pen, so I need my money.
But you said you don't need it anymore.
I mean, well, I didn't need it, but now I need the money. So,
But before this, I did not agree anything from your offer or anything. I think it's unfair.
In certain situations, an act done before a promise to confer some benefit in exchange can be good consideration for that promise if this act is performed at the promiser's request, or the parties agree that the act would be remunerated with a benefit, for example, subsequent payment. Or if the payment had been promised in advance, it would have been legally recoverable. That is, it would have been able to be collected at the promised time period. Past consideration can be considered good consideration in these situations because the act is a part of the action in a certain contract.
Assalamualaikum, Hakim.
Waalaikumsalam, Adrian.
So I heard you need a pencil.
Yes, I desperately need a pencil for my sketching, but I don't have one.
Don't worry, I have just a pencil for you. It's very big as well. So, would you like to buy this pencil from me for 2 ringgit? For 2 ringgit.
Oh, I don't even have cash.
Don't worry, you can pay me next week. How about that?
Oh, really?
Yeah. Yes.
Yes.
Next week on Monday.
I deal with it.
Okay, so you have cash at that time?
Yes.
All right.
Cash.
So do you accept my offer?
Yes, I accept your offer.
All right.
Thank you. You're a lifesaver.
All right.
Roscorla purchased a horse from Thomas, who then verbally assured Roscorla of the horse's good health. Later, a dispute arose when the horse was found to be unsound, leading to a legal proceedings. The central focus was on the difficulties in enforcing promises made after a contract, especially when lacking a new exchange. Roscola claimed that Thomas' verbal assurance should be legally binding, while Thomas argued otherwise. The court dealt with the complexities of promises made after a deal and the need for something new in return. This case really mattered in contract law because it stressed how important it is to have exchanges to confirm promises after a deal is done.
Issue of the case, the plaintiff sued damages for the breach of contract but was unable to sue the defendant based on this false assurance. The issue was whether the promise that has been made by the defendant was a consideration or not. In this case, there was no consideration. Next, the decision of the case. The court of Queen's Bench was in favor of the defendant because of plaintiff failed to prove the breach of contract, and the plaintiff's statement and the defendant's statement was made after the sale was completed, and there was no consideration for it to become a binding contractual warranty. Lord Denman, Chief Justice said it may be taken as general rule, subject to exemption, that the promise must be made co-extensive with the consideration. In the present case, that the only promise that would result from the consideration as stated and be co-extensive with it would be to deliver the horse upon the request. The precedent sale without warranty, though at the request of the defendant, imposes no other duty or obligation upon him. It is clear, therefore, that the consideration stated will not raise an implied promise by the defendant that the horse was sound or free from vice. The general rule is that the consideration passed and executed with support of no other promise than such as would be implied by law.
For the facts of the case, the defendant, Casey, oversaw some patents owned by the plaintiffs, Stewart and Charlton. The plaintiffs later signed a document that read, "In consideration of your services, we hereby agree to give you 1/3 share of the patents." This payment was in exchange for work that Casey had already completed. The plaintiffs applied to have this document expunged from the patent register after Casey registered it to claim his 1/3 interest in the patent. The issues of this case is the plaintiff stated that the document was not a deed and therefore was required to be supported by consideration before it became a valid agreement. The issue was whether what Casey had already done was past consideration, in which case it would not be good consideration, and the agreement to give him an interest in the patents would be void.
I would like to continue with the decision or outcome. The Court of Appeal held that Casey must have assumed his work was to be paid for in some way. The work done was not just a matter of goodwill, but something a manager would have expected to have been paid for. The promise to pay was, therefore, just a crystallization of this reasonable expectation. Bowen LJ said, a past service raises an implication that at the time it was entered, it was to be paid for, and when you get in the subsequent document a promise to pay, that promise may be treated as an admission which fixes the amount of the reasonable remuneration. Therefore, Casey's password was a good consideration and the agreement was enforceable.
I am of the opinion that this particular rule of consideration plays an important role to maintain a sense of fairness, particularly for the formation of a contract. Without such a rule, a person could simply bring out any gifts from the past and claim it as the consideration for a present contract. That would bring about a world where nobody would be able to trust a gratuitous gift or present because it could be the preamble to a contract that they would never have agreed to.
The idea of past consideration can be a good consideration, such as that if you perform a task before someone offers something in return, it might be acceptable in given certain conditions. For instance, if they specifically ask you to do it, or both parties know that there would be a reward, or the reward could legally be assured beforehand. For me, I understand that it is about promoting fairness and clarity in agreements. However, we also need to be aware of the importance of a clear communication to prevent misunderstandings in forming a contract.
In my opinion, past consideration can create ambiguity in contracts. Relying on past action as a basis of a contract might leave everyone confused about what the terms of the agreement are. This lack of clarity could lead to arguments and make it hard to enforce contracts. Basically, without a clear understanding of what each party is supposed to do, disputes are more likely to happen, making it tough to figure out who's responsible for what.
As for my concern, I think it is essential to strike a balance, drawing lessons from the past while remaining open to fresh insight and forward-looking strategies. The call to prioritize present and future considerations reflect a mindset that is attuned to the dynamic nature of our world, encouraging agility and resilience in decision making.